You have a job to do and you have a client to protect. You can't just, have good hair and a good suit. You have to tell a cohesive story.
Hello, and welcome to Working with me, Dan Doriani, hosting a podcast where we explore faith, work, culture, and the way believers can make a difference in their corner of the world. Well, hello everybody. My guest today is Christopher Frost, who is a lawyer. He's a trial lawyer. That's a special kind of lawyer. He represents a prominent firm that I can't name on the air. We can't talk about his cases in detail. We're familiar with that concept. There are about 1.3, 1.4 million lawyers in America. Only 7,000 are trial lawyers. There's constitutional law, family law, state law. You could probably tell me all kinds of other lawyers, contracts, immigration, you name it. But you're in an unusual group. All you do is trials. Just give us an orientation, Christopher. You're an elder in the same church I'm in. And so you're a believer, you bring your faith to work. But first, let's talk about what you do. What does a trial lawyer do, and what do you do?
Well, thank you for having me here today, Dan. It is a pleasure to be on your show, and I call it your show because I have now become a fan of your podcast. I think this is a great opportunity for people to hear from other believers in communities where they're trying to live out their faith. And what I would say in a nutshell, a trial lawyer, while it's not everything that I do, it is the main focus of my practice. And I would say that a trial lawyer is chiefly an advocate, and whose job it is to and I will say it, to win a case, to win a position, to make the best argument to either convince a jury or a judge, or in some cases both, about the rightness of your position. And it could be a number of positions about a number of different types of cases, as we'll probably get into. I really only focus my practice in one area of the law, which is the civil area, as opposed to the criminal area.
Which means nobody goes to jail.
Right.
But there may be financial penalties.
That's right. That means in the civil world where I deal with, if I lose, my clients could pay a lot of money. If I win, they don't pay any money, and that's the oversimplification of it. But there could be other aspects or regulatory issues involved as well. And
your firms, the firms you represent, are financial institutions, banks, insurance companies, organizations of that nature. So they're big. Your firm is pretty big, maybe very big or pretty big. We're not going to get into that, but these are not tiny little sums of money. These are fairly substantial cases, yes?
That's right. The clients that I have might have a case that is, somewhere in the hundreds of thousands of dollars, but most of the cases that we deal with from on a regular basis are anywhere from 10 to 100 and maybe even more million than that. So we're talking about tens of millions and in some cases hundreds of millions of dollars that is at issue, shall we say.
That's pretty weighty. So how do you decide you're going to take a case? And I know you're not at the apex of your firm, so you probably get assigned a case from time to time, but you maybe have some choices also. And how do you handle it when you're enthusiastic about a case, like, oh my goodness, I want to fight for my guys? And how do you do it when it's maybe not quite as easy to think this is a great project to be on?
Yeah, that's a great question, because you're right. I mean, the world that I live in, I am a part of a very large firm, so I don't typically just decide whether I take new clients or not. A lot of what I do is for institutional clients that we have a regular relationship with, and our job is to assess and defend them in the litigation space across the nation, depending on what lawsuits they have against them. Now, but it's a great question about whether I'm enthusiastic or whether I'm not as enthusiastic about the case. And I think, so maybe I could rephrase the question a little bit by saying...
Because lawyers do that. May I rephrase?
Yeah, exactly, Your Honor. And if I could do that, I would say, in my world, unlike a lot of gifted trial lawyers, a lot of them actually are in smaller firms. They're in more boutique firms.
Right.
And so what I do is in a larger firm with larger clients that are more regular is really maybe the question would be to say, what cases would I tell my clients that this is a good one to take to trial?
As opposed to settling.
Correct.
Yes.
Correct. And so I would say there are three things that I would consider, and then I'll maybe connect that to what I think you were also getting to as far as what do I do in a situation where I think maybe there is a problem, maybe we haven't, maybe we're going to be arguing something that I might personally believe is really not the best argument to make because there's a mistake involved that needs to be vindicated and it's on my side. Maybe I have to deal with it.
When we say a mistake, we don't mean deliberate malfeasance. humans make mistakes.
Typically not. I mean, I've been doing this for a long time, and there have been very few times, and count on one hand, where you really had someone who, in the corporate world, meant to do something wrong. It does happen, but it's not normal. But the flip side is the plaintiff lawyers, which are my adversaries. Their job and their bread and butter is to make every mistake
look like
seem
malfeasance, right?
Look like it was on purpose.
Yeah, because we can get more damages.
That's right. You make it as terrible as you can make it.
Right.
I would say maybe the short answer, and how do I decide how to advise my clients whether to take something to trial? One thing is you have to just assess the merit of your position. You have to know, what are the odds that I'm going to convince a jury that I'm right? And we have to learn.
Chances of success in a phrase.
Exactly.
Right.
Chances of success will be number one. Number two, how reasonable is the other side? In other words, the other side may assess their position as weaker than you do, in which case they might come to you and say, we're willing to settle for a lot less than you may have thought. And while we may say, well, we can win this case in trial for sure, it's way more efficient and wiser, frankly, to settle out of court because the other side is being eminently reasonable, or maybe even
generous,
downright conciliatory. And then
or ignorant of the merits of their case, you might say.
And sometimes that's true as well. I would say, and thirdly, when in the world of larger companies that deal with when we take things to trial, by and large, corporate America is trial averse, and they are risk averse. And so, but there are times when you might have a situation that you need to advise your client, or they may actually have a DNA, kind of bent themselves that says, this is something that's reputational. This is something that if we don't go and actually fight this.
Yeah, if we settle, it makes us look guilty, and that damages our brand, our reputation, our credibility.
Precisely. Or it could be that if we settle, then it gets in the water, and then the plaintiff's bar knows, hey, this company A or company B, if I bring this kind of lawsuit and make enough noise, they're going to pay some money. Right. And so you have to get out ahead of that.
So
and not every
easy
issue.
Payday, in other words, for some people.
Right.
So let me state it a little bit differently. Maybe it's not the same question. Thank you for that answer. But do you feel bad? I mean, are you discouraged when you prepare for a trial and then you can prepare up to a year, right?
Right.
A case can string out in various ways for even multiple years.
Could be longer, yeah.
Are you happy when a case doesn't go to trial? Or are you crushed, you put in all that work preparing for the trial? Or is it case-by-case variable?
I would have to answer that question, and that is really a great question, because what you're asking about is the highs and lows of a lawyer who gears up to do things that are
Can I say it this way?
Yeah.
If somebody said to me, hey, Dan, prepare a lecture, and then, 2 days beforehand, I worked on it for a month. They said, hey, you know what? We got a preliminary copy of your notes somehow, and that's all we need. You don't need to come. You don't need to give us your talk. I would not feel great about that. I would say, I came prepared to present something to you, but I don't think it's the same necessarily for a lawyer.
It's not really, because so there may be a couple of scenarios that, let me sort of subdivide that. Yeah. So one scenario could be, to your question, that maybe it is a case that we've briefed up and worked on for a year or more, and we have briefs into the court, and the judge decides that the issues that are legal issues, because judges typically decide legal issues, whereas jurors decide factual issues. So if there's a factual dispute, before a judge can apply the law, the judge would have to send this case to a jury. But if the facts are reasonably not in
agreed
dispute,
upon.
Then the judge says, well, then I apply the law, and the law means that this side wins or that side wins. So sometimes what happens is we do all the work, and before we get to trial, we come to a point in the road called summary judgment, and the judge can, as a matter of law, say you win. Now, even without even arguing to the judge, and so we get an order. So I have to say, when I get an order issued from a court saying we win, then I don't feel so bad about not showing up.
All the doubt is removed, right.
On the other hand, I would say there really is, I would have to say, a both and to this question to give you that if I had prepared to make an opening statement, or I prepared for this trial for so long, or this oral argument in front of an appellate panel, and then it doesn't go because it settles. And that happens. That happens sometimes. It could happen in the middle of trial. It could happen right before. It can happen 5 minutes in. Correct.
Or halfway through, or 2/3.
Exactly.
Anytime. And I learned that from watching law.
From watching TV, yeah.
Lawyers have said that many times. That's the realistic part of law programming. Anyway, go ahead.
It is, and I would say I have the same sort of mix of low in the dumps and euphoria at the same time. And I think that's personality driven. There are other guys who do trials, other trial lawyers out there who might have a different take on this. For me, there is a euphoria to being out there without a net and to knowing that you don't know and it's going to be wrapped up in how well you did. But then again, when you get a settlement and you don't go to trial and your client is happy with the settlement, then it's almost like you've done your job and you get satisfaction out of that. So there is a bit of, well, I don't have to have that moment where my worth, essentially, and I say this tongue in cheek, your worth is going to be decided by whatever verdict there is going to be.
Jury says.
Yeah.
And of course, you don't believe that your worth is decided by that.
Exactly.
Secular people are probably way too hung up on their visual, audio, legal success rates and so forth. As a believer, that if you get an adverse decision, whether by jury or judge, you're still beloved by God, and it's not as devastating to you. I'm sure it's still hard when you have a negative jury decision or a judge says, sorry, you got to admit your guilt.
That point you just made was one of the things that was probably one of the biggest points of God growing me in my walk in my career as a lawyer, because before I was a lawyer, I was an Army officer for about 8 years on active duty and did a lot of really super dangerous things we won't go into, but I don't ever remember being afraid or being fearful in the Army. Had a lot of responsibility, a lot of danger, but when I got into my second career now, I've been doing it for over 20 years, but I really had to wrestle with this God's telling me in His Word, don't be anxious, don't be fearful. And I had to realize that for me, in my line of work, that the stress that I was feeling, you could call it a lot of things. It's stress, it's this, it's that. Bottom line is it's fear. And for me, it was fear that I knew that the essence of my job was to obtain a result for my client that I knew deep down I couldn't conjure. I couldn't do on my own. And so that tendency or that complete, back and forth inside, it was fear. It was fear that I can't, and is my reputation going to be bound up in that? And so the Lord really taught me that early and humbled me, really, not necessarily in big losses. I mean, I've had big losses and big wins in cases, but it really was more of a process for Him, exactly what you just said, of lovingly, bringing me back and letting me know that, yes, I'm going to win, I'm going to lose, and He's gifted me to do what I do well, but I don't present myself as worthy based on my own work.
Performance that day.
Yeah.
Let's go back to the technical side for a minute, if I may. One of the things that made me want to have you on this podcast with me is some similarities between the life of a lawyer and the life of a pastor or preacher. Now, there are differences, but the similarities are lots of preparation. There's a lot below the surface. The iceberg, what we say is a fraction of what we know. There's a lot of notes we have scattered here and there. At least the way I preach and teach, I've always got more material than I'm going to cover in that 35 minutes or that hour, whatever the case might be. But I'm glad to have it, because then if a question comes up, or to be honest, if I feel like I'm for some reason losing my audience as I'm speaking, I think, okay.
I'm sure that would never happen.
Night school goes from 6 to 8:45. I'll sometimes say to them, hey, do you all need a story? And so I have this sort of bag of potential stories that aren't really all that necessary. But, they've worked a long day and they're at night. And of course, we have classes here at the church at night too. So you need to tell a story sometimes that might not totally be necessary. You also have facts that you know well, but you think they're not germane for most people. They're there if it comes up in a teaching time. If you got to say, okay, why did I say that? Well, there's 7 reasons why I said that. But I only share it because I asked. We've had a couple of broadcasters on this podcast, and they actually operate the same way. They have things that they're going to say in a baseball game or a football game. They have things that they might say depending on what happens. And one, who was one of my first guests, Joe Buck, color codes everything and has it in sheets and so forth. This must be stated. This may be stated. This probably won't be stated. But there's a chance, and I'm going to keep it handy nearby. Certainly that's the same for me when I speak. Is it the same for a trial lawyer? The difference is I get to do a monologue in a sermon.
Right.
When I'm teaching, it's monologues with approved breaks.
Yes.
In an appellate law situation, it's I hope to talk, and I hope to get most of my points out before I'm interrupted by one of the judges.
Right.
So I've said a lot. Comment as you wish.
as a trial lawyer primarily, but having also had the privilege of arguing in front of certain appellate courts, the approach is different depending on what type of work I'm going to be doing. And to your point, yeah, you're right. I mean, a monologue is obviously an opening statement or a closing argument. I get to go on, and I don't get interrupted typically, and I get to really develop things and paint a picture. Bring
it all together.
It's kind of what I talk about painting. That sort of, you start little and then you work in, and then you put the color in, but you keep your same theme throughout. There's a way to do that. But then the other piece, like for the appellate court idea, is I go up to the podium, and I don't do this a lot as a trial lawyer, but there are times when I know I've got a panel of judges. It could be a trial court judge. I'm arguing about the case in the first instance. It could be that we're on appeal, and I've got 3 or 4 or 5 or 6 judges asking me questions, and they're going to interrupt me all the time. And so the challenge is, it's almost like your color-coded friends preparation, where I have certain boxes that I have to say,
right,
and so I'm going to get interrupted. So how do I pivot back to the things that I want to say? But have I done enough preparation where no matter what they ask me, I mean, it's not possible, but we always aspire to the idea that I don't want them to ask a question that I haven't thought of, and that I haven't thought about what at least I would say, even if it's one sentence, I would be conversant on it. So those are the margins. And that's sort of, I would say that I approach it. It really depends on what I'm doing. If I'm questioning a witness, for example, whether it's on the stand or even in a deposition, which you do a lot more depositions than you do in the courtroom.
Right.
And this is a mentor taught me this years and years ago when I first started practicing, is that you may have a story that you want to get out of a witness, even an adverse witness, and you have building blocks and ways of cross-examining and evidence you want to show to use and make them admit certain things, but sometimes it becomes too much for the brain, and it really becomes...
Your brain or their brain?
My brain. Okay. If I'm trying to write the entire several hours in one...
and it's like to keep every thread in mind.
Right.
So you go with the moment.
So to me, and the way I've done it is I think of it as a collection. I'm an English major before I went to law school, but I would say, it's a collection of short stories to me as opposed to a novel. If I have a novel... and I get off track, it's harder to get back into the novel.
But if you have a string of short stories, these could be 3 minutes.
Yeah, it could be a subject, a very short subpoint.
Vignettes almost.
Exactly right. Vignettes. So I think, to me, and whether I'm going to question a witness, or frankly, if I'm going to stand up and teach, or if I'm going to stand up in front of a court, I reduce my thinking down to key words that remind me of a larger idea.
Yes. So somehow this reminds me of a presentation I heard by an architect of all things in front of, it was an architect I knew, and I was invited to come. And there was a bunch of architects and designers and construction people, and she was doing a great job. I mean, she was blowing everybody away. And then one person said, "Now I have a question about that." And she pointed to something as a part of the building. And the architect said, "Yeah, that's the weak spot, isn't it?" You're absolutely right. If there's anything we need to work on, and I thought, oh my goodness, she's lost everything.
Yeah.
But actually it disarmed people. I'm not sure it works the same way in a legal situation because it's so adversarial. You don't want to concede things. I don't know. So that was a collaborative enterprise. Yeah. In other words, it was a presentation of projects that people had worked on.
Yeah.
It's kind of like presenting a poem to a bunch of poets.
Yeah.
And we're rooting for each other, but we're also going to say that was the wrong word, and the poet may say, "You're right, I really struggle with that word." Mm-hmm. Same with an architect. I don't think a legal situation is like that because it's adversarial. Now, you and I agree that the adversarial system is not perfect because you end up forcing yourself to be opposed to somebody when you might half agree with them. But it's what we've decided is the best in a fallen world, because the adversarial system makes sure that everybody gets their case made as well as possible.
Yeah, I think I would say I do believe that our legal system is flawed as it is because it's made up of people who are flawed. I think it is the best.
Doctrine of sin.
The doctrine of total depravity. I mean, there's a reason why the Founding Fathers made, checks and balances in our governmental system, which is another podcast, I guess, for another day. But a lot of them were Calvinists, and not all of them were Christians, but some of them were, and some of the Christians were Calvinists, and they thought, we really know that the human heart is dark, and we want to make sure we have checks and balances. And the adversarial system is really an outpouring of that. It gives the task of advocacy for each side or for multiple sides so that there's not one person who is trying to to truly advocate for many different sides at one time. You have neutrals that judge
or
between
judges,
that.
Perhaps a panel of
Judges could be arbitrators
Right.
if you have that. But typically you get your best work, you draw out, even if it's adversarial and even if not everything is perfect, it tends to draw out the rawness and the realities more, I think, more than any other system out there. And it definitely comes with its shortfalls.
But it's kind of like, I don't know if you ever were a debater at all. I did some debate.
I wasn't, but I'll say that interestingly, to your point about the adversarial piece and whether that, how you can you be self-deprecating or maybe
conciliatory or something.
Conciliatory in some way in the legal setting. I would say that you can, and I would say sometimes it's actually a powerful move for advocacy, because if what you're able to do is to know that you've got a weak point in your position, and whether you're talking to a judge, and the judge is smart, the judge has read your briefs, and you're thinking, this is my weak point, you need to say to the judge, and this is, again, young lawyers don't always get this, but if you get up and say, Your Honor, I know what you're thinking. You're thinking this, and this is a problem, but let me tell you why it doesn't matter. If you go right at it,
yes.
Or if you talk to someone and say, even if you're talking to a witness who's adverse to you on the stand, you can say, no, I think we can agree on this, right? We can agree on that, and I wouldn't even quarrel with you about that.
A little bit disarming, right?
Yeah, it's disarming, and it
makes it stronger. If you're fighting about every last thing, you lose credibility, I would imagine.
That's
you say,
right.
Look, we know this. So I'm going to I've only been in court 2 times. But one time I was an expert witness. It wasn't very long ago.
What was the topic? What were you?
I probably shouldn't say a whole lot about it because it was recently and the case hasn't been decided.
It may not
I'll
be over.
say that I was defending a church. It was in an ecclesiastical court, I should say.
All right.
But, people are sharp. The church had done something very difficult. It was the right thing, in my opinion. They made a very hard, very good decision. But they didn't execute it perfectly. Their description of what they did was poor and kind of hurt somebody a little bit. And so they were accused of terrific failure and you need to be really punished for this. And I said, no, they made some mistakes. There's no question. There was either carelessness or haste or too many people writing a document. I don't know. And it really is lamentable. And they didn't do an ideal job pasturing their people or shepherding their flock. But it was not a major mistake. So I felt I had to concede that something had gone wrong in order to make the bigger point that it was accidental, not massive, ordinary human mistakes when, there's a lot at stake. And I felt that it helped his cause.
I think you're spot on. I mean, a lot of what I deal with in the world of the trial advocacy piece is you do hire expert witnesses. It could be anything from a geotechnical engineer to an insurance expert. It could be a lot of different things, but the experts who are the best witnesses are the ones who do exactly what you just said, which is to have a conversational, non-combative type approach where they're willing to concede that not everything has to be exactly their way, but the core is absolutely unshakable.
Right.
There's some, that could be possible, but here's why it's not here in this case, because this is unquestioned. They're able to do that because jurors don't like witnesses typically that are combative about every little thing.
So that gets us to something else that people have been talking about for over 2,000 years, and we've talked about it too, the triad of logos, ethos, and pathos. I'll give you my summary, you can give me your summary.
Okay.
But logos is the reasons, the facts, it's logic, why I'm telling you the truth, my case is correct. And, you want to have the argument on your side, obviously. You want to believe that you're right. And have grounds for saying so. But ethos is trustworthiness. And trustworthiness is, I actually believe the speaker is a reliable person. And it may be because they concede things. It may be because in ordinary life you know them and you know him or her to be a lovely person and sacrificial and kind. And so this story you heard about them can't be true. Or that statement they made, they didn't really mean that because they would never intentionally say what you think they said.
Yeah.
That's ethos. It's giving people a break. Pathos, of course, is arousing emotions or feelings, which can be good or bad. I'm guessing in the closing remarks, at least at times, you want to arouse sympathy for your client. Some people might want to get the jury angry at the big bad, at the big bad corporation, et cetera.
Right.
So that's my way of talking about it. We see that in the Bible, certainly. There's lots of therefores and since thens in the Bible. And there's also, Paul, when people are mad at him, says, I founded your church. I mean, I took care of you like
Right.
a mother, like a father. I mean, you know me.
Yeah, who are you talking to? Who's telling you this?
I'm your father in the faith.
Yeah.
I mean, I planted your church.
Right.
So we see all those in the Bible. How do they inform the legal profession? And again, not the legal profession, but honestly, you as a believer.
Right.
Because your goal is not to move people however you possibly can to whatever end. You want to move people in a manner that's consistent with your faith, not manipulative.
That's right. And that's maybe a great way to start with the not being manipulative, because if you're good at it, it's easy to manipulate people. And you have to, sometimes if you're good at it, guard against manipulating people. And using that Aristotelian triangle, as you brought up, for the right reasons. And so when I will say, and I heard you say this maybe in one of our previous conversations, about some lawyers say that whether it's a judge or a jury, a lot of times will go with the lawyer they like the best. I would take some issue with that. I would say I would say the lawyer they like the best, maybe the best behaved, the one that they believe has the most character, is probably more, in my view, a tiebreaker that will win cases for you. Because, believe it or not, I mean, people have different ideas about juries, but juries, no matter who's on the jury, whether it's somebody who's, hasn't finished high school or somebody who has a postgraduate degree, and you have those all the time together on juries,
right.
they a great mix. I mean, it's part of the great part of our system. You have a diverse viewpoint on that jury. They typically they bind together really pretty well, and they try to get it right. So what that means is, on the logos part, the logic, you have to tell a cohesive story.
Right.
You can't just be, have good hair and a good suit. I mean, you have to tell a story that really makes sense. Because I've had, I win and lose, but I've had cases where I've talked to jurors after the case, they're like, we wanted to go with you, but we just couldn't get this one thing was missing. Or, another way to put it is, a lot of times what we do is in preparation for larger trials, we'll do what they call jury studies or mock trials.
Right, yep.
And they can go on for a few days, and you really pay real jury pool people to come in, and some of them actually think it's real, and you make arguments to them, and then you get to watch them on closed cameras. They consent to all this, of course,
right.
but you watch them deliberate. And what you see, and I've had people after those exercises, and I played a role, or maybe this role or that role in that trial,
right.
and it's all just make-believe because you're trying to learn.
Right.
And they say, we really liked you, but we can't get our mind around that fact. And so you gotta tell a good...
You gotta get your fact. It's gotta start with logos.
Right, you gotta start with logos. And then, I think...
but maybe what that lawyer, who's a good Christian man, maybe what he really meant was, I believe, not only I like him better, but I believe that he's making a good case. I like the way he's making his case, not just I like him.
Right. And I think he's right.
Credibility, mastery of the facts, etc.
Right. And I do think it does matter how lawyers treat the judge and the jury and witnesses. How do the lawyers treat each other? How do the jury sees even how you look at and interact with your adversary? And so everything...
Is it better to be kind?
Of course.
Okay.
Of course
Just
it is. No, of course it is. Now there is a...
Respectful, at least, even
there's
if you
a place
sharply
to be
disagree.
respectful.
Right.
That's right. There's a place to be respectful. There's also, you have a job to do, and you have a client to protect. That's the way I view it, is you're protecting an interest that you believe is right. And so you're not just all friendly and buddy-buddy with the other side, but the jury does see how you handle yourself, if you handle yourself with decorum and respect.
You disagree agreeably.
That's right.
I like to say, you disagree with your friends or your acquaintances. You can't disagree with somebody you don't know.
Well, I would say
that was a test question.
In my work, I disagree with people that I don't know a lot, and part of that is because.
Well, you know them in the trial.
Yeah, I get to know them in the trial.
Yeah,
a lot of what I do takes me to different states, and so I'm not regularly in the same area over and over again.
Yeah.
So
you're far from home a lot.
Yeah, so I'm basically, every time for me is a reset. I gotta build credibility with the judge that I've never met before. I've got to build a rapport and a respect with the other side, who is my adversary. And I've also got, if we have a jury involved, then I've got to do that as well. That's everybody. That's new for everybody. But the judge piece sometimes can be a challenge, because it's easy if this judge knows you and you're in the backyard of this judge every day versus coming in.
That's if you have a practice in your hometown.
That's right.
And they realize this is a good man. He's not trying to lie, deceive, cheat, steal. So you don't have that advantage.
No. Maybe the last thing I'll say about the logos, ethos, and pathos. The pathos piece, yeah, it's obviously true that a lot of times on the plaintiff side, their job is to try to stir the emotions of the jury up and get the jury angry and upset or concerned. And there are ways, there's an art to that. There's a way to do that.
It's probably easier to get people angry at the big corporation than at an individual who feels that they've been wronged in some way.
So a lot of what my job is actually the opposite in the world of pathos. It is, how do I bring the room down? How do I calm the room down? How do I talk in a way that not only calms them, but actually humanizes the corporation? That's a lot of what I have to do, is to show that this is a decision that was made by a person, and that person is, Jane Doe. And Jane Doe, this is what she does.
We know the name of the person the plaintiff, the person who thinks they're wrong, but there was actually a person on the other side. In our corporation, it's not faceless.
Right.
They're actual people working there. And you try to bring that up.
And that's the art.
Yeah. That also comes from our Christian faith. Everybody has dignity, everybody counts. Behind every institution, there's a lot of people, individual people.
Yeah, that's right. And I think that for part of my job, speaking about the individuals in the corporation, every case is an individual factual circumstance that we're charged with assessing and then giving advice. Because before we ever gear up and put our armor on and go out and do the trial battles or prepare for that, we have to figure out what happened, and then we have to give good advice to our clients. Right. And so sometimes that good advice,
settling.
That's right, could mean you need to settle, but it also could mean that there's a right thing to do that is in an array of choices that's not necessarily required, but it's something that is, if you have to pick the hierarchy of what the best choice is in a right, I get the opportunity as a believer to, whether I do it overtly or whether I do it implicitly, and it's just baked into my analysis and the advice I give, is to say, this is the right thing to do. Let's consider this. Let's consider that, because it could be that we could go all out and win at all costs, but even corporations know that just because you go win in court, you still got to pay a lot of money. You still have risk. There's a lot of fertile ground for conversations about what is the best result here, and it doesn't always involve
crushing the adversary.
Correct. Yeah. And so that's part of the challenge for me as a believer is, am I consistent? Over the years, I think as a younger lawyer, I don't know that I saw it this way, but as I've gotten older in my practice, I really believe that, people, we would joke, it's like, wow, the Lord really knows what He's doing when He gives us His law and He gives us His principles. Yes. In fact, I can't think of a time now that when I'm trying to give advice and I try to model that advice off of what God says is true about His universe, and I do that, it may not be always, in quote unquote, the best result in the immediate. Sometimes it is immediate,
right.
But overall, the right answer is always going to be the most protective and best answer for a company. And that's people sometimes look at that and go, well, how do you do that when sometimes companies want to shortcut and make money and wrong people? And I just don't think if people are in the middle of this world, they don't understand that really corporations want to make choices that are good and wise.
Well, even if it's only self-interest, they want to protect their good name.
Correct.
They want to have themselves presentable as a company that's fair-minded.
Right.
So they might use words like fair, good name.
Right.
We would say, well, that's because you're using justice and mercy and loving your neighbor. And that's in the back of our mind are not only biblical terms, but biblical definitions of those terms. Because of common grace, we can make some headway with people. I have one more substantive question, and that is, in a lot of fields, you can prepare, but you also find yourself in situations where it's not possible to prepare. So, for example, I'll just say I've been on any number of occasions asked, "Hey, Dan, can you say a few words to this group? They're in the building, and can you give them a greeting and give them the devotional from the Bible?" And I've got to be somewhere, and literally I'm preparing as I'm walking down a long corridor. Mm-hmm. And then I'm going to speak for 5 minutes or 7 minutes or 3 minutes or whatever. And I think politicians are in that position a lot of times. It seems like things come and go and very slowly, and then it's all of a sudden in great haste, and you've got to make a deal right now.
Right.
Do you prepare? You ever get stuck and have to fly and just hit something right now? Or do you have time enough always to prepare?
I'll give you maybe two answers to that. One would be kind of in the world of law practice, and one would be in the world of because you're a lawyer, will you speak and do this? Because you're a lawyer, will you do that? So there's sort of two separate answers. As you know, and I think you alluded to it earlier, a lot of what I do in court or in a deposition takes hours to prepare, and then only the performance of it is sometimes very
tiny
short,
fragment.
right? Similar with preaching in a way, and some kind of that disproportionate amount of time.
Right.
But there is a scenario in court where whether it's a witness, whether you're going to do a redirect with a witness, or really whether you have an argument and you're both standing up and sitting down, and then you go first and then the other side goes, and then you get a chance to do what they call a rebuttal.
Right.
Well, that's on the fly.
Yeah,
they could say anything,
right.
And your adversary, and frequently they do, and it could be something that you've never heard of before. It could be, and so you have to. So the art there is to be able to address it immediately, and that has to just come from your ability to synthesize that in milliseconds, because you do know the case really well, but you've got to figure out a way to make sense of it. And then the second challenge is, how do I neutralize that the most effectively in front of the judge? In other words, it may be that they said 3 things in their presentation, and I want to rebut 2 of them, but they finish.
And go for the weakest point, of course.
Yeah. So I stand up. The first thing you want to do is take the heat out of what was you thought the most damaging thing, and so you've got to figure out this discipline. How do I not just run off and take the bait of one thing when I know, okay, I need to.
You've got to make sure you're hitting the right thing.
That's right, and in the right order.
Yes.
The other answer I would give you is just if I'm in a gathering, I like to, as I'm walking up to a gathering, I'm usually thinking I could get called on to please do this or say an opening prayer or speak to the.
Well, you're a walking expert. It's like a doctor walking into a room.
Yes.
Can you look at my rash?
Right. Exactly right. And so I don't mind it. I mean, I want to, but I want to do it well.
Yes.
I want to, and so. An example I would give you is I have the privilege of serving on the school board of our Christian school in our church. And so if I'm ever in a gathering where we've got teachers or students, or the school board is maybe doing something official, I don't expect to speak, but I have thought about, there are 2 or 3 subjects that I know they need to hear, and that I'm going to use as my skeleton.
Yes.
And that's kind of what I do.
Yeah, that's good. All right, you ready for rapid fire?
Lightning round.
Okay, question number 1. Is there any TV show or movie that is kind of, sort of close to describing the actual practice of law?
I mean, the first thing I would say is
terrible.
The first thing I would say is
it's
no,
entertainment.
Absolutely not.
Is there one that comes even vaguely close?
I would say they're part of the theatrics about A Few Good Men that are actually real, and that can use tricks in the courtroom. I'm not going to say all the dialogue of can't handle the truth is we call that a code red. So actually that is in our profession. It's like, oh, you're not really, did you get the code red? Everybody wants to know if you did it. But no, I think that there are some things about the theatrics and how you set the courtroom up.
That's good. That's question number 1. Question number 2, what is the best book you read recently?
I'm going to subtract the word recently because there is
in the last 2-3 years.
Yeah, because there's a book that I like to reread every few years, and it is a book that I would recommend, and I do give and recommend to men that I meet with or younger guys that I'm meeting with, and it's a book called Gates of Fire by Stephen Pressfield.
Okay.
It is a book that is at the top of the list in the Army War College literature list. All of the graduate level warfighting use this, among many other books. But this book, it is about the Battle of Thermopylae. It is about the Battle of the Spartans standing against the Persian army around 480 BC. 300 Spartans and their armorers.
Tens of thousands.
And it's a true story, and is a very studied in both warfare and in religion, and his writing, as years have gone on, has been more fascinated with the Christian story. And I say that only because Gates of Fire, and I'm breaking your 7 seconds, but I'm saying this because Gates of Fire has so many redemptive themes in it through such a raw, difficult circumstance. And Stephen Pressfield, I don't think he would say he's a Christian. He's a Jewish man,
Christian heritage,
but he absolutely nails the redemptive themes about humanity that
and
God
sacrifice
built
for your people, certainly.
Yeah, and I think the biggest thing out of that book, the reason I love it is because it really puts a lot of layers into what does it mean to die to yourself, and in sacrifice to those to the left and right of you.
Others, yeah.
But not just like kind of apple pie idea,
Right.
but like really what does it mean? And they really go deep in the book. So I would say that book is a must read.
Okay. Last question. If you could do anything you wanted for 1 year, money's no object, visas are no object, travel difficulties are no object, finding a place, what would you do for 1 year if you could do anything?
All right, at the risk of sounding selfish, I guess, I would say, well, I'll include my family members in it. I would say I would
You
go.
can take your family.
Okay, so that's part of the deal. Okay.
Yes, anything you want to do.
Okay. I would go to Italy for a year. I would live somewhere in Tuscany. I would ride my road bike a lot. I would get way better on the guitar, and I would try to write. I don't ever have time to write.
About law.
I would write something
maybe.
Probably more about King David, because he's my favorite biblical character. But
Okay.
that's what I would do with my family. If I could do all that over and over
do whatever
again.
you want.
Yeah, that's
the
what I
whole
want to
idea.
do.
All right, one more. Last question.
Okay.
If you had a minute, you got a minute or 45 seconds, you're going from the second floor to the 44th floor with a young aspiring lawyer, and he says, I know you, I saw you. Give me one tip for developing as a young lawyer and becoming a great lawyer, good lawyer, whatever. What would you say?
This is someone who's already become a lawyer. They're just
like
starting
a
out.
27-year-old lawyer.
Okay. I would say find the most skilled lawyer that you can find in your firm who you admire their character and you admire their practice, but you have to admire their character, and you should apprentice yourself under them. Lawyers are incredibly, high performing, just like doctors. There's a lot of trouble in the law profession, a lot of addictive issues, a lot of things because high performers, right? But so they can do a lot of things, but academically. But I would say what has helped me, and I would say what is really valuable, is the idea of apprenticeship. And when you really put yourself as an apprentice under more of a master through a number of years, it is going to affect you and get down deep and teach you. You can make things your own, but over time, that apprenticeship, I think, is invaluable. It's not just about processing data, it's about soaking in
character as well.
Yeah.
Christopher Frost, I love your name. It's a great name.
Well,
and it's been so good to have you.
Thank you.
And have this conversation. I hope it's beneficial, even a blessing for people who listen.
It has really been a blessing for me. It's been really, really fun. I appreciate you having me on the show, and thank you for your ministry among us. And I do also wish that this is helpful and encouraging to whoever listens to it.
Working with Dan Doriani is a production of the Center for Faith and Work St. Louis. We seek to promote faithfulness in the workplace, in education, in discipleship, and in the stories of believers who've applied their faith at work. If you want to put your faith to work and change your corner of the world, visit our website, the Center for Faith and Work St. Louis. Look for faithandworkstl.org. That's one word. We'll help you start a cohort with like-minded believers who also want to practice their faith at work. This podcast is donor-supported. To keep us going, please donate on our website. Maybe more importantly, you can support us by listening, by subscribing, by sharing, by liking us, by posting us on your favorite platform, or go old school and tell a friend.